Hello, welcome to Facts Don't Lie with Justin Webb. As I sit back and kind of go through the news stories of a week, a couple things pop out and just make me want to ask, America, what are we doing? The thing that really got me going this week was related to LGBTQ rights. And as always, let's start with the facts. On Thursday of this past week, the House passed H.R. 5, which is known more familiarly as the Equality Act. So first, let's talk a little bit about what it is. Again, this bill passed 224 to 206, pretty much close to a party line vote. Three Republicans did cross over and vote in favor of the bill. Originally, it was passed in 2019. The vote, again, similar along party lines, 236 to 173. At that time, 8 Republicans had crossed over essentially party lines and voted for it, and the Democrats held a larger margin in the House, so that accounts a little bit for the difference between the two. So then next we need to talk about why was it necessary. So what sort of precipitated the need for this bill. Okay, so in June of 2020, the Supreme Court issued a decision in the Bostock versus Clayton County case. This case was actually what they call a consolidated ruling. 3 separate cases. They all kind of fit together. Actually, I think when we talk a little bit about each of the cases, we can kind of see why they put these 3 together. They all were under the same, I guess you could say, umbrella. So the first was Bostock was actually a county employee. It's a county in Georgia, Clayton County. And, he's a guy, he, gets a county job, and as county jobs often not necessarily the best paying jobs, but you got your good benefits, you got pretty solid retirement, right? So he's on his way, and lo and behold, he decides to participate in a gay recreational softball league. Once the county finds out, then they fire him. Okay, so next we have so that gives us a look at the public sector, how people have been affected, right? So the next case is, and I believe it is Allied, let me just check here, Altitude Express v. Zarda, okay? And Zarda was an employee of Altitude Express. After he had been hired, okay, a few days later, through some conversation at work, he comments, or it's made aware that he is gay. Shortly after this, he again is then fired. Okay, so now we have public sector and now a private entity. Okay, and then we have another private entity where we have RG and GR Harris Funeral Homes, who fired Amy Stevens, who initially presented as a male, was hired, and then after some time she made the announcement that she planned to live and work as a female. Again, shortly after this declaration, then Miss Stevens was also let go. So it kind of gives us a look at it. This issue is the same across the board, and we get a chance to look at it. How did it impact someone in the public sector? How did it impact someone in the private sector? So I think that was a lot of the thought process behind putting these things together. So those who were in support of the actions of Clayton County, of Altitude Express, and Harris Funeral Homes asserted this idea that the omission of sexual orientation in the original language of Title VII of the Civil Rights Act of 1964 indicated that this protection should not be extended under Title VII. And Title VII is a piece of the landmark 1964 Civil Rights Act, and it applies specifically to employment. Also covers education as well as some different areas. So that's why you're hearing them reference Title VII. So the finding of the court was that actually that protection does extend under Title VII. And it should really be noted that, this decision came from the court, which was a full court, and it was a 6-3 decision. So given the conservative makeup of the court, I think it's key to understand that this was an issue that I think a lot of people might have felt the court was going to rule in one particular manner. But I think what they did is they demonstrated, being good jurists, right? They looked at the facts of the case. They looked at the existing law, they applied it as they saw appropriate, and then they came to their decision, which is really what you would ask for your jurists to do, right? You don't want them to make decisions solely based on their political affiliations, right? That shouldn't come into play, actually. So along with this decision, as well as a few others that have come down the pike, I think we've seen that this court is consistently done that, right? They've ruled in ways that people didn't expect. If you want to reflect back on the election, a lot of people kind of felt that, that they were going to rule in favor of then President Donald Trump, and they didn't. The case that was brought by Texas, attempting to sue the other states for the election issues as they saw it. So again, you also might think, what would be the other purpose for why this was necessary? So prior to this ruling, which was just in June of 2020, right? So we're just talking like 7 months ago, more than half of the states in America, you could fire an individual for being gay, bisexual, or transgender. Nothing to do with their work performance, right? Nothing to do with any other issue, but just solely for that purpose. Which is why I get to my original question, America, what are we doing? And that's because there's already some discussion as to how this bill is going to be handled once it gets to the Senate, and the fact that the vote broke down so strictly along party lines. Okay, once this gets passed, right? The idea is then you can codify into law the decision of the Supreme Court, right? So we can make the changes in the language to reflect the findings of the Supreme Court. That would kind of minimize this being an issue that comes back to the court at a future date. Some other reasons why there would be a need to do this after this June 2020 ruling, which was unexpected by the Trump administration, sort of as a last act, late into the administration. There were two instances, one with the Department of Education and another from the Department of Justice, where they issued some statements and tried to say how they see Bostock applying. Maybe Bostock, I might not be saying that quite right. And basically they attempted to minimize the impact of the Supreme Court decision. So all of those things come into play as to why these changes would need to be made, okay? So specifically the bill, now what does it do, right? So it defines and includes sexual orientation and gender identity among those prohibited categories for discrimination or segregation, right? This would be done to add specific explicit bans on discrimination against lesbian, gay, bisexual, and transgender people in both public and private spaces, right? We mentioned before that we had this one case that was in the public sector, right? The county employee, and then the private sector with the private employees. Okay, there is some other conversation that we'll get to a little bit later regarding some of the pushback on this in terms of private entities, more specifically with religion. This is all would be applied to the 1964 Civil Rights Act. Okay, that was the landmark legislation which banned discrimination in places of public accommodation, right? Including among those courthouses, parks, restaurants, theaters, sports arenas, hotels, all that good stuff, right? So now black people and minorities could not be denied service simply based on the color of their skin, right? Title VII in particular banned this discrimination based on race, religious, national origin, and gender discrimination by employers and labor unions, and also was where the Equal Employment Opportunity Commission was created. And this gave people who wanted to, have their issues decided a way in which to file lawsuits. This Equal Employment Opportunity Commission would do it on their behalf. So then we get to the piece where now how this legislation originally and now as it's being proposed now gets into sort of education and some other spaces, right? The provision that forbids using federal funds for any discriminatory program, okay? And that's key because that's going to get to a little bit of one of the issues that I do actually have with some of the legislation, not this bill in and of itself, but some things that people are sort of trying to attach to it, or concepts that have been extended, actually one by executive order signed by President Biden, and just some of the conversation regarding the legislation as a whole. In addition to that, so by getting the Office of Education involved, this allowed to aid with the desegregation of schools, and also sort of beefed up the Commission on Civil Rights and prohibited unequal application of voting requirements, right? So then, shortly after in 1965, you had the Voting Rights Act, which was passed. And so just in a short period of time, you saw major legislation that really, made a huge impact and changed America. For those who kind of push back against this, typically what comes up is the ideas of religious freedom, right? And then there's always some conversation regarding bathrooms, locker rooms, and women's sports. Okay, so let's get back to the facts. Speaking to those three issues, right? So the Supreme Court actually, in dissent, raised some of those same issues, right? Some of what you're hearing from politicians, and typically from people on the right who don't support this legislation. And Justice Gorsuch, who wrote the majority opinion, he stated very clearly that that the court does not purport to address bathrooms, locker rooms, or anything else of the kind. He then goes on to say other policies and practices, discrimination, or if there's other justifications for them under other provisions of Title VII is like a separate issue. That's something to be cited at a later date with later cases, not these specific cases that were brought together under this one umbrella under Bostock. Okay. He also then, speaking to the concerns regarding religious freedom, mentioned that Title VII already has protections for religious employers, that there are separate federal laws, and that the First Amendment also allows religious groups latitude in their employment decisions. Okay, so those are things that are already in place that can address the issues that people may have in terms of religion. I do think it's important to note that these exceptions are for organizations that are allowed to give preference to members of their own religion in their employment practices, and that this exception only applies to those institutions whose purpose and character are primarily religious. More importantly, the work itself doesn't actually have to be primarily religious work, just that the institution meets that qualification. So let me give you like a quick example. Let's say I go to apply to be a teacher at an Episcopal school, but I'm not an Episcopalian, and there's another applicant who is an Episcopalian. They would be allowed to hire that applicant over me because they are a member of their own religion, and obviously that would be something that would be important to them to teach at their school. Although this exception does exist, it is really important to note that it is pointed out that this is not something that you can apply across the board universally, right? So the same, primarily religious institution cannot say, well, it is a tenet of our faith that, we don't recognize black people. So we're going to hire someone over anyone who's black because that's something that we don't recognize. It doesn't apply in that manner. It is specific to giving preference to members of their own religion and for no other reason. There may be some other protections for religious groups or entities out there, but I think it's really important to point out that they are given that little bit of latitude, but within some pretty finite boundaries. From here, I'd like to turn our conversation a little more to Biden's executive order, then some thoughts on these concepts of the issues with bathrooms, locker rooms, and women's sports. All right, so as we kind of turn our conversation, and we'll eventually get to where I think things start to overreach and parts that I don't like, I think it's important for us to start with the executive order signed by Joe Biden. I think it was actually signed on his first day of office. And I'm going to read an excerpt from the actual executive order, and then I think we need to break it down a little bit. So I believe it was the very first paragraph, and it says, "Every person should be treated with respect and dignity and should be able to live without fear, no matter who they are or whom they love. Children should be able to learn without worrying about whether they will be denied access to the restroom, the locker room, or school sports. Adults should be able to earn a living and pursue a vocation, knowing that they will not be fired, demoted, or mistreated because of who they go home to or because how they dress does not conform to sex-based stereotypes. People should be able to access health care and secure a roof over their heads without being subjected to sex discrimination. All persons should receive equal treatment under the law, no matter their gender identity or sexual orientation." Let's take a look at the very first sentence. Every person should be treated with respect and dignity and should be able to live without fear, no matter who they are or whom they love. If you can't get on board with that, seriously, like, dude, what's your issue, right? I mean, we're talking about basic rights that should be extended to everyone because they are a person, right? Okay. I don't even see how you could have issues with that. The next statement is where things kind of get a little bit sideways. Children should be able to learn without worrying about whether they will be denied access to the restroom, the locker room, or school sports. This piece here is the beginnings of where kind of all the issues come from. While I certainly agree children should be able to learn free from concerns over, being able to get to a restroom or a locker room, how exactly that's going to happen, I think, is a conversation that has to happen. It's a little different when you're talking about children. I'm not saying that it shouldn't happen, but how you deal with that if you find yourself in a situation with a child who identifies with a sex that is different from their biological birth, or if they are going through transition, or how you deal with all that is much, much different. And we're gonna get to the sports piece of this last, because that's a whole another animal, and it is a piece, I will tell you, it's where I have my biggest issue in terms of overreach with the policy. Again, and now as you move to the sort of the rest of that statement in terms of adults being able to make a living, pursuing their dream, whatever they want to do, without concern of who they go home with, how they dress, how they identify. Again, I think this is stuff that just it shouldn't impact your ability to do that, right? If you want to be gay, be gay. If you're trans, be trans, and your ability to be gainfully employed, to be able to have housing, again, if you're a person, you should receive equal treatment under the law. Again, that last piece, I don't understand how that could be what you have an issue with. So if you do, then really, you're the one with the problem. Okay. So let's talk a little bit, and I think, the child piece is something separate. So let's just address this idea of bathrooms and locker rooms, when we're talking about adults. All right. If you first think about this, let's just think about someone who's gay, okay? So someone who's gay is going to be in a same-sex bathroom, all right? And I think we can translate this experience to someone who is trans, but let's just look at it with someone who's gay first. They're not there trying to hook up, okay? They're there to do their business and get on about their day. And this concept of sharing bathrooms, I've been to nightclubs. I can remember the Standard in downtown LA, rooftop bar, great bar. They have a co-ed bathroom. Men and women using the same bathroom. Men and women who actually are in that same space, maybe with the intention of meeting someone, but they are more than capable of using a bathroom without causing any real consternation, okay? And then, when you get to the locker rooms, again, same idea. What's the locker room for? You're in a gym, you're in a college or university, you're getting ready for a class. You go in, you change your clothes, you get your workout in, you come out afterwards, you take a shower, you put your clothes, your street clothes on, and you leave. Again, this is not, it's not the bar, all right? It's not why people go there. And, you are making perceptions. When you're speaking now to trans people, you're trying to say that you're going to make perceptions based on how people look. All right, I've actually in the time where I was working at, which I still do, but when I at a college, there was an incident where a woman came screaming out of the locker room, screaming and yelling, "There's a man in there! There's a man in there!" And so the campus police were called. They came down to investigate. Turns out this individual actually wasn't a man. It was a woman. It was a woman with extremely short hair who was wearing baggy clothes and obviously was mistaken for a man. So, these things can happen. But again, the individual was there doing what they were supposed to do in the locker room, right? So I don't even, you're saying that you're going to make judgments based on how someone looks. And it's just not a good way to do it. Okay. And the reality too is that, unless you live in a really small town and you don't spend time anywhere outside of it, more than likely you have probably already had an experience where you have been in a bathroom or a locker room, certainly with someone who is gay and possibly with someone who is a trans male or female. And here's the real most important part of that. You probably didn't even know it, okay? So I think we just need to back off this idea that by putting in this legislation, we're going to see just all kinds of crazy stuff that happens in bathrooms and locker rooms. To me, it's just a non-starter. Okay. Now, when you want to talk about trans females and trans males in sports, as I said, this is completely different to me. And this is the biggest issue I have with where people, not what this bill actually says, but with what the executive order said, how it is, people are purporting that it's going to be extended, and, excuse me, how others may view this legislation, not as it stands, but what they think it may extend to. Okay, so again, let's go back to the facts. All right, so I'm going to start talking about Fallon Fox. And if you don't know who Fallon Fox is a trans female MMA fighter who began her career without disclosing that she was a trans female. So there's some issues in and of that itself, right? If you're going to be a trans female and you're going to fight with other women who are not trans females, they probably need to know that. So there are a couple of fights, I believe two, one for sure, where Fallon Fox actually caused a skull fracture when fighting her opponent. Okay, and in that particular fight, her opponent mentioned that that fight, it was just different. And she said she couldn't really put her finger on it. She couldn't say if it was specifically because she was a trans female, but the strength and power, in her estimation, it was just different than other fights that she had been involved in. And there's, the opinions on whether or not trans females should be able to compete amongst other MMA fighters. They do differ. Liz Carmouche, who fights at a lighter weight class than Fallon Fox, says that if she were to come down to her weight class, she would welcome the opportunity to fight her. Then you have former Strikeforce, which is separate from UFC, but also MMA fighting. Miesha Tate, who said she would not because of safety concerns. And I think, the issue of the skull fracture, which is not something that is common or that I'm even aware of that has happened in another MMA fight between women. So this also points something else out, though. So Liz Carmouche says if she came down to her weight class. So here's what we have to remember, particularly about combat sports, right? Doesn't matter if we're talking about MMA, boxing, judo, jiu-jitsu, wrestling, doesn't matter. The weight classes are there for a reason. They're there to protect the safety of the athletes. So ask yourself this. If a 10-pound weight difference between two competitors makes such a difference that the sport will not sanction a competition against those individuals unless they're at that same weight, what makes you think that someone born a biological male isn't going to have an advantage over a biological female if they are to compete against each other in a combat sport? Okay? If weight class makes a difference, certainly your biology at birth is going to make a difference. We can get, if you really want to dig into the details, men are essentially, I think, in general, you can say men are bigger, faster, stronger than their female counterparts, right? There are certainly some women who are stronger than others, and I think the situation is a little different when you talk about women wanting to compete with men, and we'll talk about that a little bit as well. All right, so the next thing for us to do is, I think we really kind of need to hone in, especially when we're talking about combat sports, this concept of power. So there was a study done on injuries and knockouts in MMA fighting. It was a 2-year study, and they analyzed men and women. And throughout the study, men had more injuries than women. They call athletic exposure, which I believe is each time that you fight creates what they call an athletic exposure. So men experienced injuries in 54 out of every 100 athletic exposures, where women only experienced them within 30 of every 100 athletic exposures. Okay, men would knock out their opponents at a much higher rate. 36% of the fights analyzed were fights by men where they knocked their opponent out versus 14% for women who were fighting. Women won more of their fights by submission, which is like some kind of a hold where you get your opponent to tap out, than men did. And there was also a strong correlation that head injuries equated to the knockouts, right? So you had more head injuries in men's fights because of you had the greater percentage of knockouts. Also with the submissions, they also noted, and this was kind of interesting, that men tended to have more lower limb injuries with their submissions, and women, it was more with the upper limbs. So it kind of makes me wonder, the musculature of the lower and upper limbs is different. Your lower limbs, obviously your legs, are larger muscle groups than most of the muscle groups in your upper body. But it'd be interesting to see exactly how that broke down in that instance. So we see, again, what does this all sort of equate to? So to me, it speaks to power, right? So the greater ability to knock someone out, injuries to body parts that are larger than others, are things that tend to happen more in male MMA fighters as opposed to female MMA fighters. Doesn't mean women are incapable of doing those things, but I do think it points out that the differences, right? The physiological differences between men and women. So if we move even, again, outside of sports for just a second, let's think about some other things where we might see some differences in terms of physiology amongst men and women. So I did some research on the LA County Sheriffs and their hiring practices. And they do have a 4-part fitness test. You have to do push-ups, sit-ups. There's a 75-yard run test, and then a 20-yard shuttle. Okay, and this is given to all applicants, whether they're male or female, and all applicants are required to pass it. What I couldn't find is what qualifies as a passing score. It would be interesting to note if there's any difference between a passing score for a man or a woman. Again, that would be an indication that possibly they're considering the need to have a different passing score based on the physiology. Okay, what they do have, though, is there are height-weight ratios that the Sheriff's Department expects male and female applicants to fall into. And all applicants have to meet it. There are some exceptions. There's a body fat percentage exception. If your height doesn't fall exactly within the ranges, then you have to qualify under the lower range that you're closer to. So there are some ways to do it. But the basics is that the scale for men and women is different. Okay, the heights and weight ranges are the same, but the weights for the women are different than the weights for the men. Why? Because men and women on the whole are built differently. Okay, this is just reality. Okay, and when you get away from reality, then you start getting into all issues. So now let's move, away from and getting back a little bit to children and high school sports. Okay, and a great place for us to examine this is in Connecticut high school track. Okay, and in the Northeast overall, there are 2 trans female athletes, Terry Miller and Andrea Yearwood, and from 2017 to 2019, their careers were cut short a little bit with COVID in terms of being able to continue to compete. But in that time period, the 2 of them combined to win 15 girls' state indoor or outdoor championships. Okay, and this comes from a lawsuit that was filed by people who are trying to prevent them from being able to compete. In Connecticut, they are allowed to compete. There's no requirements, probably in part because they are minors. No requirements for any kind of hormone therapy. There are 17 states that allow for trans athletes to compete in the sex that they identify with. There are 18 states that oppose it, and Idaho has actually passed a law that actually bans it. Actually bans trans females from participating in girls' sports. Okay, so what? In addition to the number of championships that these 2 athletes have won, so they've proven themselves as trans females to be elite. So let's take a look at Terry Miller in 2018. Won the girls' state championship with a time of 11:97 in the 100-meter dash. Okay, so I wanted to pick a race where we could, compare apples to apples. That same year, the boys' champion won in a time of 10:93. So roughly 1 second difference. And in a sprint race in track and field, really in many races, 1 second is an absolute eternity. Okay, so then I said, okay, let's take a look at what Terry Miller's time would have equated to on the boys' side. So I went all the way back to 2011, which is as far back as I could find records. And Terry Miller's time of 11:97 would have won the girls' race or finished second in every year except for one. One year it would have been a hundredth of a second into third place. But in all of those years, that time of 11:97 would not have even qualified for the final in the boys' championship. Okay? So, again, I think we see a distinct difference between athletic performance between boys and girls. Okay? And so I mentioned earlier a little bit about hormone therapy and what was the reason why I brought that up. Well, the studies that have been done show that, up to about the age of about 9, the fastest boys and girls in the world, the elite of 9-year-olds, are about similar speeds. But the testosterone that sort of ramps up in boys through puberty is now where we get the, distinct advantages in athletics, okay? And by about the age of 14 or 15, the fastest boys in high school are actually running faster than Olympic women's world records, okay? So in just that 5-year span, there's that much growth that occurs, and physiological changes that occur in the bodies of boys and girls. Okay, and then at the elite level, there is about a 10% difference, no matter what distance they're at, between male and female performers, and in jumping events, it's actually twice that, so closer to a 20% difference. All right, so this shows a huge advantage to the testosterone production in males. And it should be noted that the NCAA and I believe the IOC also requires that any, I know for the NCAA for sure, if you're a trans female athlete, they do require you to undergo hormone therapy that's an attempt to reduce your testosterone levels for at least a year. And they have shown that in the endurance sports, they do see a change in what the athletes are able to do after that hormone therapy, but they haven't necessarily seen the same in the the combat or contact sports. And there's actually a trans female who has undergone hormone therapy, is now in her 60s, and stated that although she was a runner, and that although she did notice this diminished performance in terms of endurance, that she still notices she has much more muscle mass than biological females that she knows. So, I think I kind of want to get to my final thoughts on this. And clearly, equal rights for all persons is something that we should all champion. Okay, and I definitely support changing the wording, with a very narrow application to the Civil Rights Act and to Title VII. But something else has to be done to maintain safety, number one, and when you're talking about contact sports. And, I think it's a much different deal when you're talking about a trans male who wants to compete, in boys or men's sports, or even a biological girl who wants to do the same thing. You don't have the distinct physiological advantage, even in sports where you might think you have it, right? You could say, like in cross country, like a girl who competes with the boys, she would be lighter, but she doesn't have that testosterone production to account for, that increased endurance and strength that the boys would have. So I think it's a different argument. I think it's just one of those things where you can't say it's the same when you move in both directions. Again, you're also talking about some of the other issues when you have trans females competing. You're talking about taking away opportunities from girls. You're talking about girls who are possibly going to lose the opportunity to have scholarships. And, overall, you're reducing opportunities for biological women. And when you give rights to one group, it really should not infringe on the rights of another group. And at this point, when you allow trans females to compete in women's sports, that's in my opinion, that's what you're doing. And, perhaps the answer, and I don't know, but perhaps the answer is that maybe there needs to be a space for trans athletes. Again, I don't know. But I do believe wholeheartedly that it's not right to allow someone with a distinct physiological advantage to compete against others. That's where I sit with it. And overall, the most important thing for us is to remember, facts don't lie. Until next time.